bit of price. You can get one bottle with it. You know, the Best and Cherry wine, they gave our, they gave our Emerald Coast Children's Advocacy Center $300,000 right a couple of months ago. And they had a meeting today. First time they've had, they had all the charities, all the agencies in, 15 of them. And they gave away $2.6 million. They raised over three something. You know, between administrative costs and they spend more money promoting the auction than they do administrative costs. I think they spent like $700,000. But it's grown to the largest and one of the most prestigious in the country.
Yeah, that's how.
And what is it?
Best and Charity
I got a
auction.
This is
It's a huge tent. In fact, if you want to come down,
although
up,
maybe
get
not
down the
anymore.
floor.
He's
Oh, is that right?
Well, they had this huge tent.
had
And
some
you gotta put plywood flooring down. They've got it down pretty good. You lay down your two before you got, we have like 200 or 300 people.
My goodness.
Because it's big, and we screw it, we put the two floors
I
down
can't understand.
certain distances
I
up,
can't
and then
understand
screw
why,
the
I mean, I
plywood.
listen to him talk
We're
about
carrying
this
all that
industry
double
more,
plywood.
and I cannot understand.
And then they had the
why
auction.
And they put indoor outdoor carpet on it.
who are
Yeah, that's a big
And
deal.
this is for one night?
Yeah, the auction, they have two different functions one night. There's a dinner, I think. The dinner was silent. But they had these listeners from California begging them to come. They invite them. In fact, he had a great, John Russell, the guy that really makes it happen. He had to leave the meeting for a conference call with someone in California that wanted to come, and they invited them in. He tries to change them. They tell him about each one.
Yeah.
Hey, Tony.
Hey, Tom.
How you doing, Tony?
Kind of cold, so I'm not gonna shake your hand.
Oh, no, okay.
I'm glad you're back, John.
I understand you're doing an outstanding job.
We're not giving you any more passes, right? We've actually got two cases now, the first one through.
You gonna do the invocation? Invocation? Sure. Mr. Brown, you ready to get started?
I'm ready.
Were you here last month?
No.
Well, we welcome you back. Absolutely. If you would, please stand as we have the invocation followed by the pledge of allegiance, please.
Heads. Lord, grant us wisdom and patience as we conduct the business of the county. Amen.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. We'd like to take and welcome each and every one to the September 22nd, 2016 Walton County Zoning Board of Adjustment. I'd like to thank the board members that's here tonight. We have two vacancies that we are hoping to be filled shortly. I understand there's quite a bit of discussion to get that accomplished. Scott is unable to be with us. We do appreciate our new secretaries. I believe Karen and Amy, is that correct? We look forward to working with you. Carrie did an outstanding job. She would definitely be missed. We do appreciate the planning department personnel being here. And it's a pleasure to work with our attorney. Finally, after several meetings, I think we missed one another. I look forward to working with you tonight. Thanks for coming. Are there any announcements that need to be made at this time? We have one appeal, the SRG, I believe, or SGR, one of those appeals. Anyone has any information on that?
Mr. Chairman, this is Carrie Parsons from Neighbors Giblin and Nickerson for the record. On the first appeal sanctuary at Frangista Beach appeal.
No. I'm not there
I'm
yet.
sorry, I thought that
I'm
was-
talking about the one where the county has appealed our decision. Anytime that our board is hasn't appealed in the circuit court, you know, we'd like to get an update. And I just wondered if there's anyone has any information on the appeals that has been filed with the circuit court.
No, the last filing for that was a response by the county and a request for oral arguments, and no oral arguments have been set, and no other responses have been requested by the court at this point. So basically, it's in the court's hands, and we're waiting for an update.
And that's the only appeal that we have, is that correct?
Correct. The one case that you heard a few months ago with David Pleat, he advised Mark Davis probably a day or two after the order came down that they were not going to seek appeal for the Old Florida Fish House property issue. And then the matter with the, I don't know if I'm pronouncing it right, the Elise LSA subdivision, they did file a writ of certiorari. They are seeking an appeal of the board's decision in that case. The court hasn't requested a response at this point, so we're waiting for that.
Which one was that one?
That was a blanket variance.
The setback blanket variance where the covenants had been used for building permit review purposes.
Who's filing the appeal?
And the covenants were different than the plat.
The neighboring property owners.
The neighboring property owner
Yes,
is
sir.
filing the appeal.
Not the applicant.
Right, but the neighbors.
Right.
Well, good deal. You're gonna be busy.
Yeah, we'll see. Yeah.
What about De Francesca's?
That one was heard last month. The orders went out last week. They've got 30 days from the date of the order, so we haven't heard anything on that yet.
I'm sure they will.
Yeah, they're in a position to do it if they want to.
Very good. At this time, we ask each and every person here tonight that plans to speak before this board, if you would stand to be sworn that the testimony you give would be the truth.
Yep. All those with business before the board, please raise your right hand. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you.
Ms. Parsons, you can address item number 1.
Yes, Mr. Chairman, we received the other day a letter of withdrawal to the staff. They have decided to pursue another avenue with staying within the code, so they've withdrawn their application from the board this evening.
And we have to take no action there, is that correct?
Correct.
And item number 2 that's coming up is the Leonard Lot of Record Appeal. If you would take and come to the podium and state your name for the record and explain the position of your appeal.
Thank you very much, Mr. Chairman and members of the Board of Adjustment. My name is Linda Shelley with the Buchanan Ingersoll Rooney Law Firm out of Tallahassee, and I'm here tonight representing the Lenards and Celeste Lenard individually. This is an appeal of a decision made by the planning director relating to whether or not there are 2 lots at the location that the Lenards own one of the lots. I'm going to refer to that one as 302. The other lot was purchased by Celeste Lenard individually. That's an adjacent lot, number 306, and that's the parcel ID number that the tax collector uses. And so for ease of reference, 302 is on Chivas. It's the one next to the street. 306 is a beachfront lot adjacent and right behind 302. For the record, I'm hoping that you all got the materials that I provided to the county with a letter dated September 8th. I have extra copies.
Before we go any further, you understand that it takes 4 people to vote to overturn the appeal. We usually have a 7-member, we have 4. You
Yes,
don't
sir.
have to get 100% tonight. It's okay, you're ready to go ahead and proceed.
Yes, we
You don't
are,
wanna
and we
wait-
appreciate it. Mr. Dykes called me earlier and informed me that there would only be 4 members tonight.
Okay,
Because of some real urgent issues with contracts that are pending, we need to move forward tonight.
very well.
I wanted to first make sure that the members of the board got the materials that I provided on September 8th, and they should have had a cover letter of
I believe
September.
it's all in your backup, Mr. Chairman.
Just for the record, we was called yesterday that the book was ready to pick up, and I was not able, and I will not drive to Southwalk and pick it up. We would like to have it a little ahead of time, but so you understand, I just
Absolutely.
received this tonight.
No problem, and we will walk through the exhibits that are relevant to our discussion, that both of the parties here will testify about them and walk you through them individually. So I just wanted to be sure, because I have one of the exhibits. I only provided the first page of it, and I needed to supplement number 2. Exhibit number 2 is actually a 2-page exhibit, so I'd like to hand that in to the clerk. And I have lots of copies.
Is this going to be exhibit,
Number 2.
we have exhibit 2.
Yes, sir.
Yeah.
You should have a 2 that is
Oh, it should be
on
2
one page.
pages. Okay.
You want to explain that to me again?
Yes.
It should be 2 pages, exhibit
Yes,
2?
it has 2 pages. The relevant portion of the document is on the first page that you already have, but to be clear for the record, I'm supplementing it with an exhibit that has 2 pages.
Should this be exhibit 2A?
So that would, it would either replace what you have in the book as 2, or you can mark it as 2A. I believe she gave you both the first and the second page.
Why don't we have this entered as exhibit 2A,
That's
therefore with exhibit 2 will stay in the book of
Right.
record.
Right. And I was able to speak to Ms. Parsons yesterday, and she said she had no objection to the 1 through 11 that are already in your books, and so I would move them into evidence.
So entered in exhibit 1 through 11 will be entered.
I also, as long as we're doing housekeeping, I think I'd like to give you exhibit number 12. And this is, was not provided earlier. I have provided it to the county and their council, and I have copies as well. And we will explain this exhibit. My earlier copy was illegible, and so that's why it's coming in a little bit late.
So exhibit 12 will be entered into the record.
Thank you, sir.
Go ahead.
Thank you. As I mentioned, this case is about whether the county should recognize 2 lots instead of saying that there is only 1 lot and therefore only 1 single-family home allowed. And the history that we'll go over will demonstrate that there is adequate evidence to support a decision that indeed there are 2 lots at this location, one owned by Mr. and Mrs. Leonard, the other one owned by Celeste Leonard individually. And I think in thinking about this case, you should consider these to be unrelated parties. The fact that they are married and own 1 lot is irrelevant to who the other owner is. Ms. Leonard bought the second lot with her private funds that were not part of the marriage, and she'll talk about that aspect of the case. From a legal perspective, this might as well be Mr. Smith and Mr. Jones, and the problems that it has created, this decision has created for these 2 lots will become evident as we go through the facts and the law. It is not a necessary outcome to this that you determine that this is only 1 lot with 1 buildable residence on it. And we believe that Exhibit 2, that I handed out the 2 pages of, Exhibit 2A, I'm sorry, is an important document for that reason. We are well aware that Walton County adopted a comprehensive plan in 1996, and that lots of record had to be in place before the date in November of 1996 in order for them to be entitled to have a single-family home on them. This property is in the neighborhood preservation land use category. Your policy has changed a little bit over the year, but in pertinent part, policy L-1.5.7, which Ms. Parsons has and may hand it out to you, lot of record limitations. Paragraph A allows construction of at least one single-family dwelling unit, and paragraph B defines a lot of record as an individual parcel of property created on or before November 7, 1996, owned under contract for deed or documented by a subdivision plat, deed, agreement, map, survey, or other drawing in the official records of Walton County. Exhibit 2A, you'll notice, because you see the notation on the record, was of record with the county before the operative date in 1996. Not only was this of record, but the notice, which is prior to the effective date of the comprehensive plan, includes the words "two single-family residences" in the notice of construction. So the county knew when that was filed that 2 single-family residences would be built on the property. And we, yes, sir?
Exhibit 2A,
Yes, sir.
trying to follow this, is that going to be lot 302 or 306?
When this was recorded in 1994, that was one parcel that was going to become 302 and 306.
Okay, the document 2A reflects one lot of record.
Yes.
With the language,
Yes,
there'll be 2
single family.
residents.
Yes.
Okay, go
Okay.
ahead.
Now, we submit, as far as having something of record, that this is sufficient. But it is especially true when viewed in light of the subsequent acts of Walton County that confirm that the county recognized 2 lots on the property, not just one. And that confirmation includes, and we'll go through it with our witnesses, that the tax records reflect these 2 parcels, and that the county has assessed and collected taxes on 2 parcels separately for all the years. 1998, when the Lenards purchased it as a married couple, and 2001, when Celeste Lenard purchased the 306. Case law.
For the record, the parcel numbers that you're speaking of, 302, 306, did not become of record in the tax records until 2001.
1998 was the first one for
Okay, okay, now, 1998 was a 302, that's one lot. That's
Right.
what you just testified to.
Yes.
The 306 came a record in 201.
I think that's,
No.
no, it wasn't.
When we purchased
Wait,
the house.
wait.
Okay,
She has to come up and state the name for the record.
okay, fine.
So she wants to come up and state her name to help us clarify this.
That'd be great.
She's welcome to do so.
It's Ms. Celeste Leonard. Would you please just come up and answer the question of when was 306?
State your name for the record.
Celeste Leonard. We purchased Lot 302 with the house on it in 1998. 2 years later, I purchased the lot in front of it myself in my name.
But he wants to know when the tax parcel for 306 was created.
The tax parcel for 306 was created when we purchased the property in 2001.
I believe, frankly, and it is difficult to get these records, but it was most likely created in 1998 because the seller of 302 then started paying taxes on 306.
I misunderstood. I thought you meant when we started paying tax
No,
on it.
when-
You mean when, no, Julie DeBerry, the person that we purchased the property from, she was already paying property, two separate property tax on the back lot and the front lot.
The parcel ID number was established prior to 1998 or during 1998?
302 was established, 302 was already in existence. 306 was established when they bought the front lot in 1998. I believe that's correct.
That's my understanding.
But the important thing about the tax records, I'll call you back up. The important thing about the tax records is that the case law is clear that paying taxes for a long period of time, and you'll hear that have paid for since 1998 on one of the properties and since 2001 on the other, some 18 years and 15 years respectively, over $200,000 in each instance to the county, is enough to create an inequity, an equitable, it's called equitable estoppel in the law, where it is now not fair for the county to come back and say, oh no, that is just one lot, or you can only have one single-family home on that lot. And the ramifications of that, when you think about it from the standpoint of what can they do if that's true, we have different owners of these lots. Neither one will be able to sell their lot because they don't have full title to the property. And so either you are saying that lot 306 is worthless and cannot have anything on it, which is a huge distinction. I'm sorry, I didn't mean to.
I'm not clear when 302 was prior to 1996. Do you agree with that?
Yes, I do.
306 was prior to 1996?
Yes. And I can tell you the
Now,
problem.
wait, just hang on a minute. Where is the deed that shows 302 and 306 was prior to 1996?
No, I'm sorry, I misunderstood the
Okay, that's
question.
that one. So what you're relying on is the language that's in the deed of 302 that says that prior to 1996 of record, there is language in that deed that states that they can put two residents on it. Is that correct?
This is a notice of commencement, 2A. It's not a deed. Notice of commencement, number 2A.
2A.
Yes, I am relying on that.
And this is 1998 or prior to 1996?
1994, notice
Okay.
of commencement.
Did two houses exist in 1996?
No, still only one today.
So there's just one house?
Yes, on 302.
Okay, go ahead.
Okay.
No, one more thing. We get back to the tax ID number, was in 1998. That's when that tax ID number was established.
We
Is that your
cannot
testimony?
determine, you will see in here that there was a document and it's Exhibit 3. And I'm going to show, I have actually a better copy of Exhibit 3.
Yeah, this one, so that's so good.
Can I show you that?
Here's the original copy.
If you can't read it, I have this one, I can pass it around, and there's a copy. But it's number 3. Okay. Would you like to see, or can you read it well enough, or would you like to see it?
I'd like to see that. And I'm not trying to get ahead of your
Oh, no.
testimony, I'm trying to understand your testimony.
I want you to. That's right, we share that goal. I am the lawyer, though, not the owners of the property, and they will testify.
Go ahead with your testimony.
Okay. If you look at that document, you will see that it was created, and this is why I'm uncertain about the creation of the tax records, because it shows in the right lower corner, revision number 2, subdivided parcel 22095. I am not certain whether at that time there was not direction to the tax collector, property appraiser, because we can't get those records. This document was not filed with the county.
The document you're speaking of is Exhibit 3.
Yes, sir.
There's your testimony that Exhibit 3, which is the parcel that's on the road.
Both.
Here, this one's on the road.
There are 2 parcels in that exhibit.
Okay, it's your testimony, this Exhibit 3 is the subdivision, is when the subdivision of lot occurred in 1995.
Yes, sir. 22095, it says revision number 2, subdivided parcel. That's why I am unclear about when the tax collector created 2 parcels. I know that they created one in 1998 because we started paying taxes then. But it does not show me whether or not there were 2 for Mr. Berry. The records do not reflect that.
This is interesting.
The seller.
It is the testimony that the Exhibit 3 is a 1995 document that shows the subdivision of that lot.
Yes, sir. It was not recorded.
It doesn't matter if it's
Okay.
recorded.
All right, I just wanted you, I didn't
Because
want
there's a
to.
lot of unrecorded subdivisions, in my opinion. We get that from the planning department later, but, okay.
Okay. So we're seeing a pattern that in 1994, the year before, the then owner comes in and gets and we have plans that reflect her ideas for construction, and you'll hear what happened, that she got off the path that she was on to construct the 2 residences, that she has a notice of commencement in 1994 for 2 single-family homes, and here is the subsequent plat that shows the 2 lots that are referenced in the notice of commencement. Another exhibit that I added because I thought it would help clarify was number 11, which just shows you an aerial view of it. But when you look at the county's map, Exhibit 10 shows you, and I don't know whether you're familiar with the development called Dunes of Seagrove, but Exhibit 10, that looks like this, it's in color. If you go on the county's website now, you will, and you all have done this, and you click at different ways, and you can see it in different. So if you zoom in, you can see the lot that's next door to Dunes of Seagrove. If you have good eyes, you can see a line in between the house and pool and the beach lot. But if you click on again, you will see the line. Shows residential preservation, and you see the line. I am perfectly aware of the disclaimer that's on the county's website that says, don't rely on this, and this doesn't count, and things like that. And I am not saying that this was on the county's website before 1996. There's no way that it was. I am saying, though, that to a person who is trying to investigate whether this is 1 lot or 2 lots, the county treated it for all purposes as 2 lots until just a few months ago, when a prospective purchaser of the beach lot asked to pull a permit and then was told there is no separate lot. There is no, that you can't build a house on that lot, to be more accurate, which takes away a significant amount of the value of a beach lot in Walton County. I think, and I'd like to have the Leonards talk to you about the documents and walk us through this a little bit, but I think you have an opportunity to cure this situation. There is record evidence before 1996, coupled with the behavior of the county after 1996, that whole time, that would allow you to recognize 2 lots and the ability to build a single-family home on each of those lots. And at this time, I would like to ask Mr. Houston Leonard to come up and talk about the purchase of the first lot, 302.
May I ask you a question about
Certainly.
Exhibit 3?
3.
Exhibit 3 shows an easement that was established on this 1995. Is there any document that that easement was recorded in 1995?
I don't think so. It's in existence in 1995.
I'm
They
just
built it.
asking, is there a document that shows it was recorded in 1995?
The easement to get to the front lot,
Yeah.
that's the one? Come on up, Houston, and we'll talk about that.
State your name for the record, please.
My name is Houston Leonard. When we were buying the house and lot on Chevis in 1998, we were provided with that document you have there, which is from Emerald Coast Associates showing the plat and that it was registered and it had the seal on it for both lots. We are also, when we were doing the deal with Julia Berry, now Scandridge, she had an attorney in Texas who produced language that he required so that she would be able to have an easement. That document was drawn up, but the closing attorney, Colleen Cofield, may or may not have filed it. I have a hard time finding things in Walton County's records, and I'm because I live in Atlanta, maybe that's why I have a problem, but there are a number of things that don't seem to exist anymore. I can't find them. That's one of those things. I had to give them the easement, but whether or not Colleen Cofield filed it, like this plat here, maybe she didn't. But there's no way for me to tell from the records that Walton County keeps. But we prepared that easement that you see on the plat was prepared as a deeded easement. And we signed it. The attorney, her attorney in Texas, made sure that it gave her, that we would be taking care of the concrete, that we'd be taking care of the easement and all that.
Okay.
So,
It's my understanding that there was a deed that you bought. Which parcel did you buy from these people to start with?
302.
302?
The northern parcel is what it's called on the deed. North 165 feet.
This piece up here?
Yes, sir.
You
Yes,
bought that piece?
Yes, sir, the road piece.
And there was an easement that, at that time,
We signed it.
there was an easement
That's reflected on that
to who?
Julie DeBerry.
who had retained ownership of lot 306.
Okay, at this time, in 1998, the Bears retained ownership of 306, and you signed an easement, she signed an easement for you to use that.
No, we signed an
Use-
easement giving her access to the back lot that she owned.
Ingress egress easement.
Yes, sir.
It's not to the beach, it's ingress egress in 1998.
Yes, sir.
And you did that from this unrecorded instrument in 1995.
Yes, sir.
And that's on your deed.
Not on my deed that we got from her. We prepared a separate easement deed that like I said, I can't tell you that it was filed because I can't find it in the records. I know that we went through all the negotiations to sign it.
And I'm gonna
And-
move along on this. The lady that owned 306, did she have title insurance?
Julie DeBerry, or
Whoever, is there title insurance reflecting that that easement is of record?
we have title insurance that we purchased when we bought the house in 1998. We had lender's insurance and owner's insurance that was prepared by First American, by Colleen Cofield.
But you
Well-
don't know if there's insurance, title insurance on this lot that will state there's the easement of record to get to this lot.
The second lot, the 306, we purchased in 2001. Celeste purchased in 2001, again, getting owner's title insurance on that from First American, once again,
Do
Colleen
they
Cofield.
insure ingress egress? So you have a copy of your policy. I mean, I'm just trying to establish, the easement.
Yes, it's, I walked on it today. It's
You
there.
walked on, but is it of record? There's got to be a document, if it's of record
Right.
with these transactions.
If it's of
it's
record, the
either
record
indeed
was
or
not.
Sorry, just one minute.
I'm sorry.
She's a little vocal.
Speed up, Lou.
There
You
has to
have
be a
priority.
document with an easement, a warranty deed, title insurance. I mean, if she bought it, there should be something referencing that easement.
This is the policy we received.
Right. That policy that we're looking at, and I'm glad to introduce a copy of it in the record, ensures against a lack of a right of access to the land. That's one of the things that it insures against. I'm looking for a.
It insures the ingress, egress?
Yes.
Okay.
It insures against a lack of it, which means it ensures that it was present. I'm looking for a date, May 7th, 2001.
It's insuring the easement.
Yes.
Make some copies.
If you'll come back up.
Yeah, if you would, make a copy. Put it in the record.
If you'll, do you want us to wait for that and distribute it? We're glad to do that.
He's gonna make copies.
Go ahead.
Okay. If you would just go over the documents that were reviewed by you to ensure that the necessary legal requirements were met when you purchased the lot in 1998.
In 1998, we were starting negotiations in 1997, and we closed on the property in January of 1998 because Ms. DeBerry wanted to do a 1031 exchange, and it would work out for her. During the negotiations, we found that she had split the lot. They gave us, Ms. Cofield had ordered up this plat from Emerald Coast Associates, so we received that prior to the purchase of the house. We also received, these are the originals of what I have here. These are hard to open and hard to read, but they are the originals. These are better to read.
The originals,
Plans, plat plans, and house building plans for both houses. And in buying the 1998 purchase, we received the plans for the house that we were buying.
you have a set of plans that shows the plot with two houses on it.
I do.
And it was prepared by Emerald.
No. These plans were prepared by an architectural firm. Emerald Coast Associates did the survey and the platting of the two lots. I believe to make it clear, what you have in front of you shows that the property was originally surveyed by Emerald Coast Associates in 1992, and that's when the DeBerrys received the property from, they purchased the property. And it shows on there that the original survey was done in 1992
That showed the division of the,
of the one lot. This is where the government lot 30 was separated into 5 separate lots. This one, this in 1992, they bought the first lot, number 1, from that government lot 30, split off of 5. So 92, they split, they get the lot, they bought it from their seller, and they get the plans made up in 1993 or 4. I believe it was in January. No, those are the revisions. 6/28/94, they get the plans to build 2 houses. And
That's number 12.
You
That's
can-
an excerpt of this because I didn't think that you wanted all of these in the record because they're house plans. And this is this is number 12 is an excerpt from this plan, which is for the second, this is the plans for the second house. They were, yes, sir.
1993.
These plans were created in 1994, 6/28/94. It should be, we should be able to tell that on Exhibit 12.
These are hard to read.
And these received a notice of commencement on 11/8/94.
Right.
And then they built they got the plans done in June. They started building the house on the road, Chevis, the north lot, the north 165, where the house is presently. They put in to build it, and I would imagine they would have filed the construction plans with the county in order to get that permit to build the house that we currently have.
Do you have 1 permit or do you have 2 permits?
I don't have any permits.
But there was a permit.
There was a permit issued for them to build the house.
But notice the commencement, was-
For 2.
there's 2 permits. In what exhibit is that?
94.
Exhibit 2.
2A.
2 and 2A.
And just so you can get a timeline, they did the plans to build the house in June. They pulled the permits in September, I believe, was it? The notice of commencement, November. And then, according to the plat prepared by Emerald Coast Associates, they split the 2 lots, the 1 lot, into 2 parcels in September of 1994. And that is the subdivided parcel 22095, I'm sorry. They get the plans, they build the house, they split the lot, the house and the lot off in 95. Because now they have a completed house on the north parcel, the 165 north, and they are now going to build the south, or the beachfront house. So they split that in 95. Mr. DeBerry,
Hang on a second. Okay, go ahead.
Mr. DeBerry is a aviation owner of an aviation firm in Texas, and Mr. DeBerry flies over to oversee the construction of the house on Chevis, the north parcel. He flies over 8 times, and he flew back 7. He landed in the middle of the Gulf of Mexico and died during the building of the Chevis Lane house. So that's why Julie DeBerry is selling the house, is because this was going to be their retirement, their dream and all that, and she no longer wanted to even see the house. So that's where we came in to buy this house. We could not afford to buy the house and the beach lot. And so she said she would continue to market 306. We would buy 302. She gave us the plat. She gave us the plans so that we could have the plans of the house as
Hang on.
constructed.
Tony, do you want to, are you listening to him or you want
I
to
am.
wait on that?
So I'm just-
Okay? I don't want you to miss this.
No.
We need to
Yeah, we
take a
need
little pause here for you to,
No, I'm listening.
go ahead.
And Willa Hertwig was our real estate agent. It was our understanding at that time she was either a commissioner during that period of time, or she was head of the planning department at that time. There's no reason for me to even suggest that she would not give me something that was in error. Colleen Cofield, one of the only attorneys down here during 1998, I guess, that did closings. I mean, they probably a lot now, but she at that time was the only recommended attorney that was on the street. She came highly recommended, like I say. She wrote title insurance for First American. You know, that's a great title company. I use it all the time myself. So we have a competent real estate agent who is familiar with the tax, not the tax plan, but the land development code and the comp plan. We have a real estate attorney who is the preeminent attorney in the county. And we have an owner in Texas who we never meet. But this is all presented to us to engage us to buy this house, and we did. Based upon the title insurance, based upon the title review, and based upon Colleen Cofield's representation that this was a plat and parcel. There's a embossed. It was made clear to me that you got to feel the embossment on that. That way you know that this is an official document. So whether it was filed or not is, at the time that we purchased the house, that's all you would do, Mr. Johnson, if you were buying a house.
That's all you can do.
That's all you can do. So we moved forward after buying this in 1998. And in 1999, the Dunes of Seagrove applies to build a crescent-shaped building the size of the one down in Destin. And we fight that building so that they would have to build something that would be more, which it's not, but more in tune with the residential preservation neighborhood. And we got them to build 3 buildings, 3 condominium buildings of 74 condominium units and 30 single-family home residences. The property is 14 acres. The density for that residential preservation area next to us is somewhat like 6 or 8 per acre. During the time that we were fighting the Dunes of Seagrove because we felt that it was not an appropriate development, we sued the county and the Dunes of Seagrove for their violations of the county code. We entered into a settlement agreement with the county and with Dunes of Seagrove in 1999. In it, there were a number of stipulations which would help us because they were going to build their building 5 foot from our lot line. And I got them to agree to a 25-foot lot line. This is a 5-story building. So after they constructed this, and in 2001, we purchased the front lot from Julie DeBerry. Celeste did. We did not have the money to buy the lot in 1998, but Celeste owned a property down in Inlet Beach that she bought from her grandmother with her money when she was single, and the estate, through eminent domain, acquired that 2 acres down in Inlet Beach to make a retention pond for the widening of 98. So we rolled that money, she did, into the beach lot, and we were able to buy the beach lot then in 2001. In 2002, Dunes of Seagrove wanted to file their plat for record, and I objected to the filing of the plat because they had violations of their development order. One of the violations was, and there were numerous, but one that's important today, is that they had a setback of 25 feet from the property line. They built the elevator shaft in the front condos next to my house 12.5 feet into the setback. So they have a 12.5 foot setback up on the beach side. And we went through 8 months of meetings like this in order to see if they could file their plat. In December of 2002, the county made the determination that I had no right to complain about the setback violation because In 1999, when I entered into the settlement agreement, we owned only the front lot, and Julie DeBerry, Scandridge, owned the beachfront lot. And she owned that beachfront lot all the way up until 2001 when we purchased it. So there was no violation because there were two lots, Julie Scandridge's lot and our lot. So the county at that time based its decision to take 12 and a half feet of my view of the Gulf of Mexico upon there being two lots. So,
Let me just pause and ask you if you understand what we're talking about there. And you can see from the building, the county asserted that the 1999 settlement with the owners of Lot 302 for 25 feet didn't count as to Lot 306 because they didn't own Lot 306. It was a separate lot owned by someone else.
Do you have a copy of that settlement in the pack?
The settlement agreement, the settlement document is in the package of exhibits, as is the minutes. And I wish the minutes were clearer. Exhibit 8 are the minutes, and the settlement agreement is Exhibit 7.
Settlement agreement 7.
Yes. And first paragraph, first sentence, will set its building a distance of at least 25 feet from the common property line between it. Sure. Common property line between its property and the property owned by Houston and Celeste Leonard. That's 302. So when the Leonards complained that they were only 12 and a half feet from Lot 306, the county said, well, they didn't have to be 25 feet because you didn't own, that's a separate lot, and you didn't own it.
Where is that language in this settlement agreement?
Well, this is the settlement agreement that's the 25 feet. The minutes are number 8, and you have to, it isn't clear, but in fact, they allowed it to be 12 and a half feet. On page 4, the big paragraph at the bottom of page 4, in the middle of that paragraph, discussion also occurred regarding the amount of property Mr. Leonard owned at the time the plans were approved.
But there's no clear language that they referred to as 306 being the second.
Right, you have to know which.
Okay, but we can't assume that. I was looking, you said it's in the settlement agreement, but there's no clear language to that. It just refers to his lot. It does not specify clearly that there's lot 302 and 306
It only refers to them by name.
and 302.
Yes, sir.
And it does not refer to 306.
It does not use parcel numbers, it just uses owner names.
But it does not refer to the owner's name of 30 of the second lot, if you want to call it that.
Well, if you keep reading, Mr. Lane stated that the original property owned by Mr. Leonard was that portion above the elevator shaft, which he has just testified about. The portion on the Gulf side, which is 306, was purchased later, in other words, after 1999, when the settlement agreement was entered into. The only relevance to this is that the county used this ownership issue of the second lot to interpret the settlement agreement to not be binding on that second lot.
To be clear about the county, and when you refer to the county in this document, you're referring to the county commission.
I am referring to Mr. Lane, who worked for the county at the time.
Okay. In reference to this county document, you're referring to the planning department director.
Yes, sir.
Okay. I just want to be clear when you
Yes, sir.
speak about the county property appraiser is a different entity. Now, this is the county planning director.
Yes, it is.
Okay.
Okay. Right, the action indeed in Exhibit 7 was against Walton County. It was the planning department issue, and that's, both 7 and 8 are relating to the land use adjacent to this property. Just briefly, have you paid taxes on your home and Lot 302 since you purchased it?
We have, every year.
Approximately, how much in taxes have you paid since you owned that property?
$200,000.
I'm going to show you Exhibit 4, if you will refer to that, and ask you to identify that.
This is our warranty deed that was given to us by Julie Scandridge for the January 2nd, 1998 purchase of the north parcel, which is the north 165.7 feet of that lot.
If you'll, we're referring to Exhibit A, which refers to the description of the property as the north parcel at the time that they purchased it. I'd like to ask Celeste Leonard, I'm sorry. Do you have any questions for Mr. Leonard?
Not at this time. Anyone on the board?
Did y'all speak to Mr. Prescott, the architect from the 1994 project?
I have never spoken with Mr. Prescott or his firm. I was given the documents, and
Was the house already built when you bought it?
we bought the house built.
Right,
So-
but he designed both, and he is showing a property line.
Yes, that is the property line that shows on the plat and on the county's record of the future land use map when you pull it up on the internet.
Okay, thank you.
Celeste, just briefly. And I think Mr. Leonard has gone over that you had separate money and that you purchased the beach lot, is what we'll call number 306.
Correct.
Okay. And what steps did you take to ensure that everything legally necessary was done before you bought that lot?
I hired Colleen Cofield as our closing attorney, and she wrote title insurance on the property just as we had done when we purchased the home.
And you received a copy of the plans that are depicted, I think they're up there, but the excerpt is Exhibit 12, is that right?
Absolutely. At that time, then gave us her plans that for the second home to be built on that property. At the time, it was an empty lot, but we did have hopes of eventually building another home on that property.
And have you paid taxes on that property each year since you've owned it?
Absolutely, since I purchased it from day one.
And approximately how much in property taxes have you paid?
Approximately $250,000 on the beachfront property, more so than on our house.
Do you have any questions of Ms. Leonard? We will reserve a little bit of time for rebuttal. Did you have some questions?
Was there an easement on her deed for the second lot? I mean, like legal access to it? I mean, like it said it ensured the access. Was the easement mentioned on the deed, if something like this lot with an easement to it?
The warranty deed for the second lot is in your package, and I'm not a surveyor, but if you'll look at that as opposed to the first one and compare those, it is Exhibit 9. Is this the warranty deed that you received?
It is.
And it references parcel identification number, and the last 3 digits are?
306.
Okay. And the description of it, it doesn't have a north, south, east, west. It just has the whole parcel and lesses out 302. That's my understanding from a non-surveyor comparing the language in the two. That's Exhibit A.
It does, for the record, it does not have an easement mentioned in the survey.
It's not in the deed. It's not
I
mentioned.
mean, not in the deed.
she owns the whole lot. There's no easement of anybody through her lot to the beach. There's an easement from 302 to 306.
Where is that at? In the
That
deed?
was on the plat
No, but it's not a record.
that we know of. That's why we,
There's not an easement on an instrument that's been recorded. 302 does not have legal, less than it said, easement along the east boundary, south boundary, etc.
it
This
wouldn't lessen
deed,
it.
this deed here does not have this legal with an easement such and such that goes to the road. Just for the record, there's not an easement instrument of record except this unrecorded document of 1995.
There must have been a separate document that,
We prepared a separate easement
right,
agreement.
but,
We bought 302.
right, but 306 should have an easement back through 302, is, I think, what
That
you're
was the
saying.
easement that we prepared, was to give 306 access of ingress and egress.
We had to, her attorney from Texas, when we purchased the home on the 302 spot, we had to make sure that we granted an easement so she would have access because she still owned 306. He wanted to make sure that she had access from our property, our house, to the lot. So that easement was granted when we purchased 302.
I believe that the easement was granted. I believe that somewhere it is recorded. But there is not an instrument in our packet that shows that easement. And, you know, and we can move along, because I believe that it was prepared, and I believe it should have been prepared, and I believe it's recorded. But we're gonna move along.
Okay. Can you look at Exhibit 6, please, and identify this? Is this the, in orange? I think you have a colored picture of Exhibit 6. And does the orange area reflect your parcel?
It does.
Okay. And that's referenced in the next page, which is part of Exhibit 6, and it references 306. I think that's all the documents that we have, and we'd be happy to answer any questions, and I reserve a little time for.
Oh, absolutely. You will have the opportunity to come back at the end for summation, and you also have the opportunity to help us get the testimony from the county position. So, absolutely.
Thank you.
Ms. Parsons? You have 5 minutes.
I'm going to talk really fast. Good evening, board members. For the record, my name is Carrie Parsons from the law firm of Neighbors Gillen Nickerson here on behalf of the Walton County staff this evening. I do have a package for you, which I gave to your council to hand out. Thank you so much for doing so.
What exhibit would this be?
This would be exhibit 1 or exhibit A for the staff. Okay, exhibit A. If we can have that in the
With short.
And I'll briefly go through, tab 1 is the actual letter that Mr. Dice wrote. He wrote it with the assistance
This,
of
excuse me, this is exhibit what?
staff exhibit A.
Okay.
Tab 1 under staff's exhibit A is the actual determination letter that was given by Mr. Dias. He wrote it with the assistance of Mr. Matt Carpenter. Mr. Dias unfortunately was ill this evening, so Mr. Carpenter is here and he will give some facts to it. As you will see in the letter, it is a request to determine whether or not there is a lot of record for 306, and then whether or not, based on if it is a lot of record, it has the density rights afforded by the Walton County Comprehensive Code. So when Mr. Dias made his determination, as you'll see on that last sentence, he said that he's of the opinion that there is no substantial evidence that the lot in question, which is that back lot of fronting the beach, is actually a legal lot split and therefore a lot of record. If you go to tab 2 is the policy which counsel for the applicant has already stated to you. It's policy L-1.5.7, which is the lot of record limitations. As you will see under C, the lot is an exception to the density provisions. And it allows for single lots of record that were established prior to November 7th, 1986, to be entitled to construct at least one single family dwelling unit. Lot of record is clearly defined in B as meaning the individual parcel or property created on or behalf or before, November 7th, 1996, the key magic date. Owned under contract or deed or document by the subdivision, plat, deed, agreement, map, survey, or other drawing in the official public records of Walton County. As you will see, the applicant presented with you a ton of documents, but unfortunately, none of them can be found in the public records of Walton County.
I have a question.
Yes.
There is a large number of unrecorded plaques that is in the property appraiser's office. They are not, it's not recorded, it's unrecorded.
I can go through that.
Well, that's what I'm getting to. I mean, because to me, this right here is an unrecorded survey. To me, this fits that definition. You know, and the planning director, Ms. Herdwood, I believe, in what was it, 98. I mean, we dealt with this in real estate profession. We created them. We recorded, not recorded, but we sold lots without it being recorded. And it was clear then that anything that showed a split or unrecorded was subdivided. So tell me why that's not true.
And you're right, if that had been recorded prior
No,
to November 7th,
not recorded, unrecorded.
right, if it's an unrecorded, unfortunately, the specific code provision does not permit, it has to be recorded, and that's exactly what it says.
There is a large number of lots that is of unrecorded plats that is not recorded. It's a piece of paper. I can go to the property appraiser's office and pull them out, and they're unrecorded. They're recognized. There's people sells them. They're still being sold.
Right.
So help me understand why this does not qualify for that.
Yes, sir,
Yes, sir, you're exactly correct. There are a number of unrecorded subdivisions in Walton County that did not go through recording in public record, as is the requirement today. The BCC identified a finite list of those unrecorded subdivisions prior to 2000 and recognized them as legal, as if they had been recorded. But that is a finite list. We have people come in every day that bring in things that, development plans with great intentions that never went through a development process, never went through a lot split process, and never got recorded in public record. But we do have a finite list of those that the county has recognized.
I will accept your statement. I respectfully disagree with it, but I do accept, but I respectfully disagree with it from personal involvement back then and even today on stuff that this right here is all you needed. And if you had this prior to, that's all you needed. I had property that fell under it, and it was not recognized as far as, I don't think the county commissioner list, as you said, that it had a parcel ID number. And we're going to get to that, I'm sure, but like I said, I accept it, but I respectfully disagree with it. Go ahead.
Okay, thank you, Mr. Chairman. Actually, speaking of which, with regards to the argument that has been raised that the county's behavior up until this point has been conflicting with what the county's behavior is now, they use the broad term County. And as the chairman has pointed out, the property appraiser and the tax collector are two separate entities under the law. They're two separate constitutional entities under the law. The tax collector actually is required by law. They cannot refuse to record a deed. They must record a deed. It doesn't matter if it's insufficient or if it's incorrect. It's a ministerial duty of the tax collector under Florida Statute 28.222. And actually, there's been some situations in which the Board of County Commissioners in the past has tried to raise an objection with the tax collector filing a plat or filing, or the clerk of court, filing a plat, or the tax collector filing a deed without their permission or without a notation that the county hasn't approved it yet. And the Attorney General has actually had this raised to them in the past. And it is in the way past, but it's still a valid Attorney General opinion. It's 1975 Florida Attorney General Opinion 43. And what it was the Board of County Commissioners requested that the tax collector refuse to actually accept a deed and record that deed for some roadways and for some other things that would dedicate certain things to the county, because the county didn't sign off on it, and by law the county has to sign off on that. And the AGO specifically went back and referred to that Florida statute 28.222, which states that the clerk must record all deeds that are presented to them. Also, the property appraiser, they also have a ministerial duty to assess all property within the county, and that's Florida Statute 192.011, and it says that all property must be assessed by the property appraiser. They don't have a duty to actually look and see whether or not a valid lot split occurred. They just have a duty to assess the property based on what the deeds out there and based on the property parcels out there from what has been recorded. So that's where we run into this conundrum, or we run into this issue where it wasn't the behavior of the county, the Board of County Commissioners, which has the authority and is required to be the one that does the lot splitting or recognizes a split lot. It was other constitutional officers that did that, and that actually goes towards the argument of equitable estoppel.
I have to take and point out that there was a transition from 1996 to 2016. And from 1996, on a number of occasions, the other planning directors allowed instruments that was recorded to be billed on. If this was presented prior to most likely 2006, the planning department would allow them to do so. So the county commissioner, in my opinion, in a period of time, allowed these instruments that was recorded, recognize them. It's only in the last 4 or 5 years or 6 years that this has been tightened up on. So I think that, a lot of this, is an issue when you assess this lot with the amount of money that they being assessed, and then you say you can't build a structure on it. Yeah. Whenever there was a transition that it was allowed that their several directors would allow them to do this. So when in generality, when you say that the county commission does not allow this at once upon a time, and I think it reflects in Exhibit 8, the county commissioners, and Larry Jones being one of them, and they're listed in there, that it's a little vague, as they say, but they did recognize this as being a lot of record.
Well, and I will get to that and rebut that issue too on Exhibit 8, along with all the exhibits I'll go through and rebut that. Just really quickly on the equitable estoppel, there are 3 elements of it. The first element, which is lacking here, is that you have to have representation as to a material fact that is contrary to a later asserted position. We don't have that here. The tax collector, again, and the property appraiser are 2 totally separate entities. From the BOCC, law is clear that they cannot bind the county and vice versa with the actions that they take. Going to the exhibits, actually, I'll go through, start with Exhibit 2A, that notice of start with the title insurance that was presented. I just wanted to clarify for the record that looking at this title insurance,
It's for the northern lot that's adjacent directly to that road. And again, there's no easement that's actually in this. And you can see on the second page of it, it shows the land referred to in the policy, and the land referred to, the legal description, lines up with the exhibit that the applicant has presented with the 1998 deed, which was for that northern lot. The notice of commencement. We're not arguing here today that there can't be more than one residential lot or residence built upon the lot. We're arguing what was requested of Mr. Dice was his determination as to whether or not there were two lots out there and that there was a legal lot split. And none of the record evidence has demonstrated there's a legal lot split. The notice of commencement that was given to you only has the legal description, that was the legal description used in the 1992 deed, which was the whole entire lot. Again, that notice of commencement doesn't go towards the effect that there were actually two lots out there.
One second.
Yes.
The county does not object to two structures being built on it.
Well, I'm not saying that. We haven't looked at that because that's not what they were being asked to look at. They were being asked to determine whether or not there was a legal lot split out there of two lots. And that's what you're here to determine today, whether or not Mr. Dice's determination that there is not a legal lot split.
Well, the question I have here is, would it be simple to do a lot split?
It would require a land use change after the land use change, because in residential preservation you can't do a lot split, and that's what it's currently, the land use is, but it would require that, and then once that would be done, it would require the lot split after that.
So it would be a time.
It would be
timely-
probably, we were estimating
It's not a
about
simple
90
lot
days.
split. They can't just file for the lot split.
No,
It's in-
correct. You'd have to do a land use change beforehand.
And part of the issue is because they don't, technically, legally speaking, they don't own, you don't have the same owners. You have the north part that is owned by the husband and wife, and the south part that's owned by her only. So it's not as though they can just combine the two.
But if it was a simple lot split, they probably would combine to get it split.
That would be on them if they wanted to
But
do
it's not
that. Yeah.
simple. Go ahead.
So again, the notice of commencement, it had no relevance to whether or not the lot was split. It did say that two single-family residents at the time could have been built, and as the law states, though, that if you get a permit, it expires after 6 months if you are not actively working on it. Exhibit 3 of the applicant's presentation, the replat that was submitted.
I have a question.
Yes.
If they had a permit and they were actively working on it, when they started the first house, would they not have actively started working until they finished the second house?
If he had not deceased.
Okay.
That's the question here.
Yeah. All right.
And again, Exhibit 3, which is that plat that has been submitted to you all, which I guess demonstrates that it was subdivided, that was never recorded into the public records that we can find. We've done our search of the public records, and no one here can actually state that it's been recorded. And the problem is, it has to be recorded.
I disagree with you, and we done discussed this earlier. I think it is an unrecorded instrument that can be recognized and could have been, had been recognized. That's my position on it, so we don't address that.
No, and I understand that, Mr. Chairman. I'm just stating, under the county's comprehensive policy, it says that it has to be within the official public records by November 7th of 1996. But moving on, Exhibit 7, the settlement agreement, had to do with the applicant's challenge of a development order of the adjacent property owner. The case, again, had nothing to do with whether or not their lot was split. No determination was made, and as you can see by reading the settlement agreement, there's nothing that determines that there was a valid lot split out there. All that was acknowledged by the county is that they owned adjacent property.
And I think, would it not be your agreement that from the settlement agreement that the county recognized that there was 2 lots of record?
No.
Is why they did not have a claim as they testified?
No, and I think they were talking about Exhibit 8 in that, and no, we would not agree to that is the case. We would state that all the county acknowledges that they had standing because they owned some property out there. They didn't acknowledge that there was a lot split. There's a specific process, and there was a specific
Did the county acknowledge
process
that there was 2 lots?
They recognized that he was an adjacent property owner.
Did the county acknowledge there was 2 lots, property
No,
owners?
they didn't. They did recognize that there were separate property
Okay.
owners in Exhibit 8, not in the settlement agreement. They
Okay.
just recognized there were adjacent property owners. In Exhibit 8, it was a final plat approval hearing, and all that was determined by the county there was to approve the final plat. It wasn't a lot split. And
Exhibit A, we acknowledge that there was 2 lots, or 2 property owners.
property owners, not
Property
lots.
By the Exhibit 8, which is the minutes, and the minutes is which Larry Jones is the commission, Tim Powell, Lane Reeves, Kenneth Pridgeon, Greg Kitchens are the commissioners of record.
And they didn't acknowledge that there were 2
But
lots.
they acknowledged there was 2 lots.
They did not.
You
There
just
was.
stated that they did.
No, they acknowledged there was 2
property owners.
property owners, but they didn't even acknowledge it. Mr. Leonard stated that there were different owners. All that the commission actually did in their official actions is on page 8, and it states that a motion by Commissioner Kuchen, excuse me if I pronounced that wrong, seconded by Commissioner Pridgeon, to approve the Dunes of C final plat contingent upon the client placing a fence around the dumpster, bringing the landscape buffers into compliance with the code to, excuse me, sorry, bringing the landscape buffers into compliance with the code to research and apply the issue addressed by the Planning Commission regarding turtle-friendly lighting and bike paths and beach access if they were stipulated conditions. That's all that they actually took official action on. And as the law states, a comment made by a staff member is not an official action of the county. And the comment made by the staff member was solely that he only owned the property in the northern part before, as opposed to both property.
Who was the
or
staff
both
member?
parts of the property.
Who was the staff member?
Mr. Leonard. Laner? Or, excuse me, I'm sorry, Mr. Lane.
I'm Mr. Leonard.
Okay.
I apologize.
Mr. Lane was who? The planning director. And it's your testimony that the planning director statement doesn't hold water?
My comment is that the law states that that's not an official action of the county. And again, there's a specific process for lot splitting.
If the planning director, this is an issue, one planning director would allow this lot unrecorded, in my opinion, and you have a different planning director with a different interpretation.
And Mr. Chairman, he never said he allowed it. He only said that Mr. Leonard only owned specific portions of it.
Which recognized that he was an individual property owner on part of that property.
Correct.
That there was 2 property owners.
There's 2 property owners. It doesn't mean there was a legal lot split out there,
But
though.
it could have been his interpretation. You
That's
don't know that.
speculation.
You don't know that.
Neither do you, Mr.
That's
Chairman.
right.
And that's why I'm trying to state that it's just speculation at this point in time. Again, with regards to, I think we went through all of the exhibits. There's nothing in there other than the notice of commencement that was actually recorded. The comp plan is clear that it has to have been recorded prior to November 7th, 1996. And I'm going to have Mr. Carpenter come up here for the next few tabs.
Sure.
And tab 3 is just the definition out of the Land Development Code. I'm not going to go over that one. Tab 4 is lot splits. It's just a little summation that the county actually has on its website. It's a good little reference to have. But we're going to focus on tab 5. Mr. Carpenter, can you actually state your name and what your official title is for the record?
My full name is Charles McDonald Carpenter. I'm the planning manager for Walton County.
Okay, and were you involved with anything pertaining to this application?
The appeal application? Or-
Excuse me, the letter or anything to that effect?
Yes, I drafted the letter after a lengthy meeting with Lois Asur, Mark Davis, and Sidney Noyes, a letter to our county attorney and assistant county attorney, where we reviewed this case in detail on my day off, in fact. And we came to essentially the conclusion that is detailed in Mr. Dice's determination letter.
And Mr. Carpenter, can you tell us what the process, looking at tab 5, section 11.03.01 of the Land Development Code, what the process is for lot splitting?
Well, essentially, where any minor or major development includes subdivision of land, the final approval of a development plan.
I can't hear you.
I'm sorry.
Essentially,
Well, let me just skip down to the minor replats and lot splits. Approval by the director is required. Proposed plat may receive final approval by the director of the Department of Planning and Zoning without the requirement for separate approval by the Board of County Commissioners where the plat conforms to the development plan provisions.
I'm sorry, Mr. Carver, you'll have to slow down and speak up for me.
Okay.
Thank you.
I'm going to read this a little bit slower.
I appreciate it.
Where the plat conforms to the development plan and the provisions of this code and involves only a minor replat or lot split. For the purposes of this section, the following shall constitute a minor replat or lot split. Where one single parcel of land is being divided into only two separate lots or parcels that conform to the requirements of this section, or in the converse, where two parcels of lands are being fused into one single lot or parcel that conforms to the requirements of this section.
so what does it require, who does it require approval from?
It requires approval from the Director of Planning and Zoning in this context.
Are there exemptions under this requirement?
There are some exceptions.
And where can they be found?
They can be found in section 11.0301, subsection B of the Walton County Land Development Code.
And as it pertains to this specific application, would it fit under one of those exemptions?
There are 4 exemptions available. This particular case fits in none of those 4 exceptions.
Okay, and if you switch to the next page, 11.03.04 requires an application process, right?
Yes, sir. Yes, ma'am.
Back in 1995, were you able to determine whether or not there was a lot split process at that time too?
Ordinance 91-4, otherwise known as the Unified Land Development Code of Walton County, specified almost exactly the same process.
I respectfully disagree with that. Now, it may be a record, but the county you never had to follow it. All you had to do, and I can give you OR book and page where you deeded it, and they accepted it, and it never was rejected. It might have been like a lot of the other that was not enforced. I did it.
I won't dispute that, but I won't suggest that it was legal either.
Let me check.
It's kind of like unrecorded plats.
Yes, sir, and the county has accepted a finite number of those for recognition, and there is a definite list of those.
And then I just have one more question for you, Mr. Carpenter. The GIS maps. I know that we've already gone over that there is a disclaimer on there that don't rely on them, but how are they determined, how the lots are split in that map?
The parcel layer is derived from the recording of deeds at the clerk of court. That information is transferred to the property appraiser. The property appraiser actually creates those map parcels in the GIS system. That information is transferred once a month to the planning department into our GIS system. So those are derived from actual recorded deeds. They reflect legally owned parcels. They do not reflect lots of record. They just reflect that a parcel has been created and somebody owns it. It does not speak to whether or not a county process was used to recognize the subdivision of that land.
in 1998, did they have the GIS of record? Did they have the technology to do that?
The property appraiser has had the technology, be it manual technology, where they were actually drafting this stuff by hand
I'm talking
for
about-
some time before 1998.
Talking about the correlation between the planning department and the property appraiser. Was it, you said the GIS was at the property appraiser and it was transferred to the GIS of the planning department today?
Yes, sir.
Did that exist in 1998?
And that's done electronically now. I would suggest that it may not have been done electronically in 1998, but the process was still the same. It may have been done on paper.
And Mr. Chairman, just lastly, tab 6.
Excuse me, may I ask Mr. Carpenter a question?
Pardon me?
May I ask a question of Mr. Carpenter if he's finished testifying?
Are you finished? You're not
no.
finished?
Do you have any more questions of Mr. Carpenter?
No.
Okay, then, yes.
Mr. Carpenter, looking at tab 2, council's, do you have it there? Would you agree that even without an application for a lot split, if one of these documents that listed in B is of record before November 7, 1996, that the county would recognize it as a lot of record?
Yes, if it was recorded in public records before November 7, 1996, we would recognize that as a lot of record, and that essentially is the definition of a lot of record in our land development code and our comprehensive plan.
Thank you.
And Mr. Chairman, lastly, tab 6. I'm a visual learner, so I put a timeline together for y'all. It goes through the different deeds that have been presented as exhibits from the applicant. Exhibit 1 was the 1992 deed. The entire parcel, again, was in that one deed. You can see that in 1995, there was a house that was built, and that was Exhibit 5 of the property appraiser's report. You can actually see that on there. Then you see on November 7th, 1996, that's the key word in the comp plan, and that's the key date for the cutoff for a creation of a lot split via deed. It wasn't until January 2nd, 1998 that this appeared as a lot split in the deed that was for the northern part, and that's in Exhibit 4 of the applicant's presentation, and then Exhibit 9, which was the April 27, 2001 deed of that southern parcel. Again, Mr. Chairman, there's nothing in the public records that demonstrated that this was a lot of record prior to 1997. The comp plan is clear, although it may not have been enforced in the past. It is clear that to look and determine whether or not there were lots of records, you had to look and see if there was something in the public records, anything in the public records that demonstrated the lot split as of November 7th, 1996. It was not here, and that's why Mr. Dias has found that and determined that it was not a legal lot split, and there are not 2 lots of record. There's only 1.
Thank you very much.
Thank
Any
you.
questions? Ms. Shelby?
Thank you very much. Just a few issues for clarification. The title insurance policy related to Lot 306, not Lot 302. If you compare the legal description that was attached, it matches the legal description on Exhibit 9, which is the total 302 less and except, etc. And so this is not a title insurance for the first lot. It's for the first home and lot. It's for the second. I think Mr. Carpenter's testimony was candid and clear. You didn't have to apply for a lot of record before 1996. If there was something of record, it didn't have to be a plat. And using the county's policy, which is clear and is cited by the county attorney as dispositive, it can be documented by a subdivision plat, a deed, an agreement, a map, a survey, or other drawing in the official record, and in the official record of Walton County is the notice of commencement in 1994 that reflects 2 single-family homes. And we've given you as much of the supporting documentation and testimony about that transaction as we can. And I think it is important here, equitable estoppel is just fairness. Is it fair for the county to deny that there are 2 lots upon which each one can have a single-family home based on this record? And we think it is not fair, and we are not applying for a lot split. We are asking you to recognize that at the present time, and since the beginning, there have been 2 lots on this property, and each one of them can have a single-family home. I'd be glad to answer any other questions. I think that it is obvious that it was not the property appraiser that allowed a home to be built on Lot 302. It was the county. Pursuant to permits, a certificate of occupancy was issued, and so saying, oh, well, it wasn't us, it was somebody else, it wasn't somebody else. It was Walton County that allowed the first house to be built and that recognized that 2 could be built.
Any questions?
I had a question for Planning Department. Mac, was a survey required to obtain a building permit in 1995 to your knowledge?
No.
I don't know.
No.
No.
No. They did not, we did not start requesting surveys until 2008, I believe, or 2009, when we started having a lot of issues with structures being built.
Just a second, Mac.
On the property, so no.
What would have been required to obtain a permit for 2 residences on that property at that time?
What I believe occurred, this was 1 lot, and prior to 96, we believe there may have been covenants and restrictions in the neighborhood that allowed 2 dwellings on this 1 lot. We believe those covenants and or deed allowances or restrictions have been extinguished by MARTA. This lot is entitled, that if this lot was still in one piece, it would still be entitled to 1 dwelling under the Residential Preservation Land Development Code, or component of the Comprehensive Plan Land Development Code. We don't dispute that at some time in the 90s, you may have been able to put 2 houses on 1 lot. That was what is applied for, and that's referenced in the notice of commencement that shows 1 lot, 2 houses. That would not be allowed today, unless the covenants and restrictions were still in effect. We would recognize them. The Comp Plan and Land Development Code does allow that. But we have seen no evidence that there are covenants and restrictions or a deed allowance, deed restriction that is still effective that would allow 2 houses on the 1 lot.
Were you with the planning department in 1995?
No, sir, I was not.
When did you start your employment with the county?
September 24, 2007. However, sir, I have done extensive research in these last almost 10 years about these very kinds of things. This is not an unusual circumstance.
The question that Tony asked you is, what would it take to put 2 structures on this property, and you really don't know, because I believe...
No, it would have taken a legal description in a deed that shows that they're the owner.
They could have went to the planning department, and they could have presented a little drawing, which a lot of us did at that time, and you walked out with a building permit. But you don't know that, because you were not there. Is that
I was not there at that time, and
okay.
I've seen nothing in writing that would substantiate that.
But that's the point here. There's a lot of history that occurred in the 90s that was forgiven by the commissioners in the 2000s that today's planning department does not recognize. And I understand you have to tighten that up. But at the time, I understand the position that they're in because I've been there. And you can't testify that you have to do all this stuff when you wasn't there. Because I did take a piece of paper and put 2 mobile homes on the lot, and later I took and I sold both of them. It was okay. And that's what happened right here. This was okay to do. And you have a planning director, Mike Lane, in my opinion, he's not here, that blessed this. He knew this and he recognized it. And for y'all to say that it was not his intent, I have a letter from Mr. Lane on a piece of property on 331 that states that this lot is a commercial industrial lot. Y'all do not recognize it.
No, sir, I do.
No. You just
Let me respond to that.
Now then, you have to go and have a rezoning of it. Y'all didn't recognize it, but he did. And you can't sit there and say to these people that you can't build on this when the planning department personnel, in my opinion,
Mr.
said that
Chairman,
they could.
I recommend that we finish the fact portion.
I am
and
finishing the fact.
Then we can.
I am referencing this,
Okay.
okay?
Yes, sir.
The fact is, he can't give testimony of what it would take to get these 2 lots on here. That's the fact, okay?
Okay.
Tony?
I think I'm good.
Anything else?
Thank you, Mayor.
Anything else? Close it. Flood discussion.
Motion to close.
Second.
Second.
All in favor, aye.
All right.
Aye.
Motion.
Not sure how to word this, but I'm prepared to make a motion to approve the appeal by Mrs. Leonard.
Second. Discussion.
We have a appeal of Mr. Dice's determination that this is not 2 lots. And you making a motion to uphold the appeal.
I am.
To uphold the
said-
appeal is affirmative.
No, I believe his motion was to grant the appeal request by Ms. Leonard, or
Right.
Ms. Leonard,
To overturn,
to overturn Mr. Dice's decision. Is that correct, Mr. Fletcher?
Yes, I didn't know how to word it any differently.
So what is your motion? Motion is to,
Approve the appeal request by Ms. Leonard.
That's exactly what I said, yes.
then we have a second. Discussion.
I believe that this was submitted as with a site plan to the building department that showed 2 lots with a property line along the north edge of lot 306. And I believe that the notice of commencement prior to 1996 would say that it was granting 2 lots. I don't know if the survey was presented at that time, but something, a site plan was required, and it did grant 2 residences. And the site plan that was provided by the architect does show what appears to be a boundary. And for that reason, I believe that it was acknowledged, probably lost. I've tried to find records that I know have been submitted and I can't find them. It happens. I know of things that are sitting around in offices that haven't been filed. It happens. But to be paying property taxes, although I acknowledge that that can happen outside of a legal split for this period of time, especially in those amounts, with documents out there that exist, show to me that there was acknowledgement of a split.
I have no
We have a motion to uphold the appeal. We have a second. Tony, how you vote?
Is that motion correct?
Sorry?
Is that the proper phrasing?
It's not to uphold the appeal, it's to grant the appeal.
To grant?
To grant the appeal. Aye.
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 Second item on our agenda. We have a variance request on, what is that, the Liberty?
Liberty Fire District on sign variance, yeah.
Where is that at? Item number 3?
Yeah. Take a potty break,
Do you?
I'll go get some water.
We're gonna take a 10-minute break, if you would.
Sounds good.
That condo wasn't gonna be happy about that house that they got.
Those people that live in Liberty wants to get home.
Yeah. So does Joe.
Very interesting.
Because I live in Liberty also. So we need to go
that
to
way
the north,
too.
don't we? We're gonna call the meeting back to order. We have the Liberty Fire District proposed to modify their existing ground sign to an added electronic messenger sign. That is a clear understanding that the tax increase on houses was too much money for y'all to have that much money to buy electric signs.
Stand by just a minute. No, we actually did get a grant for it. We couldn't afford to do it when we built the
Oh,
building.
don't come here, poor mouth.
That's-
I pay your fire
That
tax.
is the, I swore.
State your name for the record.
Tony Roy, I'm a chief of the department and also a district commissioner in seat 1 of the department.
I'm Gary Hamilton, I'm a fireman.
And he's also a district commissioner.
Gary, say your last name again, if you would.
Gary Hamilton.
And you, Roger Roy.
Nope, his brother.
Go ahead and present your request.
Sir?
Present your request.
Okay, sure. We were fortunate to get a grant to build a station under the Assistance to Firefighter grant for the American Recovery and Reinvestment Act back in the stimulus money, when the stimulus money was handed out. We were one of number 126 of 134 station grants in the United States of America. So we just did get in there, but we were able to build a station. The station has been paid for by doing away with other equipment that we needed, but we were able to build the station and have it paid for. We could not afford a nice sign when we built the station. We put, actually, they messed up when they were building the station, and we used those walls to build a signage. We're trying to upgrade that signage. We've got a new grant for staffing and assistance to firefighters grant. It's a 4-year grant. Part of that is to recruit new volunteers, and this signage is there intended to do that purpose. We're trying to upgrade our existing signs. It's an existing 14-foot signage triangle. It's located directly in front of the fire station in approximately center of the Highway 90 frontage view within the property boundaries of our south station. We plan to add the LED signage to encourage new volunteers per the grant requirement, display weather reports, time, temperature, and post community messages and fire prevention messages. This LED sign will be professionally installed and be an enhancement to our community. It will also encourage community involvement in the fire department, the Red Cross, which is one of our partners, and the ARIES, the Amateur Ham Radio Club in Walton County, and also other community endeavors. We open that building up to any community-sponsored events. Our request tonight is just to, we've been to school on signage. We didn't know that you had to have another permit to build another sign on an existing signage. But we found out that we need to do that. We've been to school. We're
we've got an engineered drawing that shows what we're going to do, and we were told, I guess, LED signs are not allowed in the county, and that's why we asked for the variance. I didn't know that. I've seen LED signs all over the county, but we're here to ask for that variance.
How big a sign is it?
It's roughly the size of a 4x8 sheet of plywood, and there's two sides of it.
And you're going to take and use that sign to get volunteer firefighters?
Yes, sir. Part of the staffing and assistance to firefighter and emergency responder grant. It's a 4-year grant. It's to teach new volunteers how to be firefighter 1 to state standards, and also emergency first responders. And in order to do that, we have to train them, we have to outfit them with new gear, and we also have to recruit them. Part of that recruitment and retention is the LED sign.
You don't have enough money to pay full-time personnel like the county does?
No, sir.
You don't
We only get
you don't raise that much money? in
No,
your
sir. We
tax?
get $75 per household and $163 per commercial building within our fire district. The county does not give us any funds at all.
But you don't have enough money to provide?
No, sir.
That ain't why you're here, but it would be if you didn't have to have a sign to get the recruited.
We get no public assistance from Walton County, which is not fair because we pay into an ad valorem tax that helps pay for the.
Well, there's all kinds of opinions on that.
Yes, sir.
But anyway, you're gonna have a 4x4 LED light?
4x8.
4x8.
Go ahead.
Is this a fixed message on this sign, or is it scrolling, or?
Change it.
It's wireless, so we can make it do whatever we need
Right,
to.
once
from
you
the
put
computer.
that message in there, that message stays there until you change it.
Yes, sir.
It's not scrolling.
They can put all kinds of stuff on there.
Yeah, you
Free
can-
barbecue.
It'll have the time and temperature, like you see at the American Air on 83. You'll see it'll have the time and temperature. We can put the weather conditions, but its primary purpose is the recruitment of new volunteer firefighters.
Did you notice a big digital billboard coming down 331? Is it anything like that, or smaller?
It'll be a lot smaller than that. Yes, sir.
I understand
We've
that.
seen several of them coming down from.
Is this-
from-
I'm trying to figure what's different.
All it is, it's a 4x8 and it flashes across it, need volunteers, free barbecue, fire burn down on 20th Street.
Okay.
It just keeps changing. And, you can do, it's ads. You do ads on them also. They're gonna do other stuff on it. It's not gonna be that, because it's gonna continuously change.
Right, and we want to do fire prevention, check your batteries and your smoke alarm. We're actually teaming up with the Red Cross to install smoke alarms for free to residents, and we need to advertise that.
They're gonna use the sign to improve the fire protection in Liberty community.
Yes,
And this is a little over 90 feet from the roadway, from Highway
Yes.
90.
Yes, sir, it's on our property.
Now, do
okay.
you understand there's a 100-foot right-of-way there? Because your property is not 100 feet, your building's not 100 feet from the right-of-way. The right-of-way line, not the highway line.
No, we're actually behind the power poles. We're in our property line. As far as-
But you said 90 feet, or you
No, I
90
said Highway 90. I think I was.
are you 90 feet from the easement line? Because you're not 90 feet from the easement line.
Let's see, I think I've got the exact measurements here. We're 200 and something feet on each direction from each one of the property lines. And I can try to find, we've got it written down here somewhere.
Right, would this sign be where the existing sign is?
It's 100 feet offset from the center of US Highway 331, 133 foot width of the
Do
right
you
of
have
way.
a copy of your survey that you proposed?
Yes, sir, it was in our package that we submitted to the county, but I
Do you have that?
have an extra one.
Do you have it?
Yes, sir, and here's a big copy.
Do
of
you
that.
see your triangle sign?
Yes, sir.
That is right on your property line.
Yes, sir.
You're not 90 feet, that ain't 90 feet from the property line.
No, from the center of, it was 100 feet offset from the center line of US Highway 90.
But there's 100, that right-of-way line on Highway 90 is 100, I believe it's 100 feet right-of-way. Or 100, it's 100, or it may be 200 foot right-of-way there.
It's listed on there as a right-of-way protection zone line. You see it marked just to the north side of the.
Oh, yeah, that's right.
It's in the right-of-way protection zone.
Yeah, they're in the right of way.
There's a bigger copy if you need to see that. But it's the same copy that you got.
What, explain to me the right-of-way protection zone line.
The staff want to comment on that? It's likely to keep things.
Yeah, Mr. Chairman, no permanent structures can go into that area, but a sign's not considered permanent. You can take a sign down, you can relocate a sign.
Just
But the
wait.
100-foot right-of-way protection zone, no permanent structure can go in there.
So the sign request that we have is not affected by that particular
Correct.
protection.
It's
line.
not, it doesn't affect it.
But the proposed, the right-of-way protection zone line is different from the property line.
Yes.
And from the distance of that right-of-way protection zone line and the property line is not 100 feet. The 100 feet is all the way across 90, is that correct?
The 100 feet is measured from the center line of the Highway 90 right-of-way, not necessarily the road, the right-of-way. So from the center line of the right-of-way.
Of the right-of-way.
Yes.
Okay. So it's okay for them, they don't have to have a variance that their sign is right next to the property line?
No. The only thing would be that if they went to widen the road, they would, in this case it would be DOT because it's their right-of-way, but they would remove the sign at their expense. That's
Okay.
what that means. They would remove the sign at their expense.
Okay.
Is the sign that you're going, the LED sign, are you going to put it on top of the sign you have now, or just right over it? You know, like you've got.
Over the top of it, if you look at this drawing, it shows you the existing signage, it's a big triangle, and it's going to be right inside of that triangle. And it's going to go with the same.
I guess, will it be taller?
Yes.
Okay, so it would be, so like right now it's this high, and then you'd add another X high,
Yes, sir.
4x8 on top of that, so it would grow 4 feet in the air.
It'll actually be a little bit higher than that because we don't want kids messing with it,
Okay.
tearing it up.
Did everybody receive notice? You sent your
Yes,
notices
sir.
out?
We sent, yeah, that's another piece we learned about. We sent notice to all affected property owners within 300 feet of our property boundaries, and we met with a couple of them. We sent certified cards to them. We didn't get any back. We had one that the address was not correct in the county records, but we tried to send it to them, and it came back to us.
Any other questions?
Is there any street lighting out there? Is it bright around there, or is it a?
Yes, we have fire department street lighting, from the building
Big building.
on each side.
Any other questions?
I got one for staff.
Yeah, we're gonna get, thank you. We'll give you the opportunity to come back.
Thank you.
Mr. Brown?
Good evening, Tim Brown with Planning and Development. The reason they need the variance is the Land Development Code doesn't allow for electronic message centers, and that's what this is. It does allow for electronic billboards. Billboards is a whole different issue in our sign code. But this is probably going to look a lot like the Cope Center. The Cope Center has an electronic message center that was inadvertently or erroneously approved. It got approved, so we're not going to make them take it down, but it was actually erroneous because the code doesn't allow for electronic message center. But that's why they need the variance, because the code doesn't allow for this type of sign. As far as staff, this request does not meet the criteria for a variance because they don't have any unique circumstance or hardship. I mean, they got a grant, they've got the money, they want to put the sign in, but under our code, that's not a hardship or a special circumstance. So from our side, it does not meet the requirements for a variance.
They don't have a unique need in terms of the service that they provide? and
Sure
the
they do.
Type of the sign that does that?
Yes, but that's
Sure.
not one of the criteria in our code for a variance.
It could be interpreted as such. Anything else, Mr. Brown?
That concludes my presentation.
Any other questions? Tony?
There are some other electronic message centers out there, but they have not been approved. Because we get people, what about that? Well, it hasn't been approved. It's there, but it was not approved by the county.
So they could just go ahead and put it up.
Well, we've had some issues with that. I mean, there's a couple on 331 north of the bridge here, if you drive up through there. I mean, there's a couple there, but I just want to make the point that they have not been approved by the county.
And those would be code violations?
Yes, they would be code violations, yes.
The sign that they have there is approved.
Yeah, that is an
You have no
approved
problem
sign.
with that sign there. The
No.
only problem you have is that it's just an electronic LED sign.
Yes,
It's just the interpretation of the code. Is
Yes.
that- At the time that the code was written, there was an LED light, right?
pretty much, yes.
So it really is not a big issue as far as if the county, if there's, if it meets the hardship or not, because it's the sign. It's just the sign is a sign that could.
It's the sign type, yes.
And really, there's no issue with it.
The code really hasn't caught up with the digital
And-
era that we're in
And
now.
that's why we're here.
Exactly.
Thank you, Mr. Brown.
Thank you.
Motion, do you want to add anything else to it? Matt?
They're all over the county.
No, I live in North County, near Liberty.
Is
Make that earlier point.
Motion to close the public discussion?
So moved.
Second?
Second.
All in favor, aye?
Aye.
Motion?
Motion to approve the variance.
Second.
Discussion?
I think that they do have a unique circumstance, and there is a good reason to have signage available for them that needs to be able to change quickly and provide information to the public. And I think that outweighs the compatibility issues, given the unique character of this particular use.
Bill?
Aye.
No, you have any? No, we got to close. You taught me, tried to do this professionally. Do you have anything to say? Motion to close discussion?
Motion to close. I thought we
Second?
did that.
No? Second?
Second.
All in favor, aye?
Aye.
How you vote, Charlie? Motion to approve the variance?
Aye.
Aye? Bill?
Aye.
Aye.
Tony? You got your variance. We hope that the increase of volunteer will be a reduction in expense on property taxes. No, wait a minute, we got to do the minutes. We got to do the minutes?
Yeah.
Motion to approve the minutes?
So moved.
Second?
Second.
All in favor, aye?
Aye. I made the motion, Charlie second.
I'm sorry, guys, hold on a second. Is this for the minutes or for the last motion? You got it. For the last, for the variance request, who made the first? Was that?
Mr. Fletcher.
Charlie made the motion to approve it.
And then who was the
I
second?
second.
Okay. And then who did the motion and second for the minutes? Just-
I did, and Charlie seconded.
Okay.
Thank you.
I was not here for
Really
the
changed the meetings.
last meeting, so that I can sign this,
What
the
is that?
minutes.
Yeah, that's fine. I mean, it's ministerial, you just sign it off on it.
Motion to adjourn?
So moved.
Second? Bill seconded it?
I second.
All in favor, aye?
He made the motion, I second, okay?
Aye.
Aye.
Your office preparing the final orders now?
Yeah, we have been.
We-
I mean, some of the more complex ones we were, and I mean.
We hope that you prepare all of them.
Okay, yeah, we can do that.
Personally,
I didn't know how Mark and those
Well,
guys used to do it. but-
Mark did not do it properly.
Hope you get
because
to
we
feel
allowed the
better. Thank you, I
county to
appreciate
do
it.
it.
Lots of other staff.
Yeah, there's a lot of concerns of mine that they were not done properly.
Okay, well,
So
we'll do it.
we had to keep going back.
Right.
And I personally think that if the county is the one that
Yes,
is
sir.
the.
No, you're right.
Then they don't need to be the one.
I just
preparing.
assumed that Mark and them had been doing it,
No.
but since the
Alan
last.
Ramey always did, and we requested you do.
Yeah, well, that's fine. The, especially the past few ones have been pretty complex, so we've try to make them as appeal-proof as possible. Oh, also, on the announcements, now that I know that, I'll get you guys, or give you guys at the meeting. If there is any type of update to give.
We need to know what's
Well,
going on.
yeah, especially if the board comes back in a specific way, you know.
Well, we have not been overturned yet. We're gonna try to make sure we stay that way. But we need a good attorney. I don't know if we got one yet. You got to prove yourself.
Probably not.